And let's take appearances. Let's start with the plaintiff, please. Let's do it in the courtroom, then on the phone.
Thanks. Good morning, Your Honor. Eric Pepperman on behalf of plaintiffs.
And good morning, Your Honor. Theodore Parker on behalf of Plaintiff KeHe.
Thank you.
Happy holidays, Your Honor.
Thank you. Thank you, and to everyone the same.
Thank you, Your Honor. Good morning, Joel Odou on behalf of AffinityLifestyles.com, Inc. and the Real Water entities and personnel.
Thank you.
Good morning, Your Honor. David Spurlock, on behalf of Whole Foods.
Thank you. Now on the phone, let's take plaintiff's counsel on the phone. Do we have any other plaintiff's counsel on the phone?
I want you not.
All right, how about defense counsel on the phone?
Good morning, Your Honor. This is Jim Neale. I'm with Mr. Spurlock, represent UNFW and Whole Foods Market in 8 of the coordinated cases.
Thank you.
Good morning, Laureen Frister, file number 13217. I represent KeHe Distributors of Nevada, LLC, in 4 of the coordinated matters.
Thank you.
Good morning, Your Honor. Colt Dodrill, bar number 9000. I represent Nevada Beverage in 4 of the coordinated real water matters.
Thank you. Is that everyone?
Good morning, Your Honor. Jim Kavanaugh, Gordon Reese, Las Vegas. I'm appearing for Real Water of Tennessee, third-party defendant.
Thank you.
Morning, Your Honor. Scott Rasmussen on behalf of Hanna Instruments in the cases.
Thank you.
Good morning, Your Honor. Melissa Roos for 7-Eleven Inc. in the Henry matter, bar number 7889.
Thank you.
Good morning, Your Honor. Dallin Connect on behalf of the Sprouse entities and Albertsons LLC. We're in 5 of the coordinated matters.
Thank you. Is that everyone who? Everybody check in? Thank you. All right, so I know that this is on really shortened time, so is everyone prepared to go forward today? Plaintiffs, defendants?
Plaintiffs are ready, Your Honor.
Yes, Your Honor. I think Jim Neale is prepared as well. He's making the primary argument.
Good enough. So this was the objection of UNFW. I will allow all parties to speak even if you haven't filed something due to the fact that I set this on such short time and there has been a holiday. So I'll accept oral joinders. So let's hear then from Mr. Neale, please.
Thank you, Your Honor. Good morning. As the court's aware, these are coordinated product liability personal injury cases. I believe there are 16 coordinated under this Wren case, the first filed among them. In each of the cases, Your Honor, there are a number of plaintiffs who allege essentially liver injuries as the result of consumption of real water. The FDA has investigated, the CDC has investigated, Southern Nevada Health has investigated. Those investigations went on for a lengthy period of time. They tested dozens and dozens of samples of water, of concentrate, of ingredients. None of those investigations, Your Honor, yielded a causative agent or an adulterant that could have caused the plaintiff's alleged injuries. So this remains very much a mystery. There are before the court a number of defendants. Mr. Odou represents the real water manufacturing defendants. But in addition to those parties, there are also entities that manufacture tools and devices used in the manufacture. There are entities like my client, UNFW, who are distributors, and there are entities that are retailers like my client, Whole Foods. Those retailers and distributors, Your Honor, have an issue. And if I can share my screen, I hope that what's now visible is a picture of Plaintiffs General 0810. This, as I understand it, Your Honor, is some of the real water, not all, but some of the real water stored by my co-defendant, Nevada Beverage, Colt Dodrill's client. My client, UNFW, has a similar amount. Other distributors and retailers have a similar amount as well. And, Your Honor, that's become such a problem that the special master came up with a plan to deal with it. he recognized the fact that we have mountains of water. Now, I want to be very clear. This is not evidence, Your Honor. This is separate and apart from the plaintiff's water that's been recovered from their homes and offices. It's separate and apart from the water that's been recovered from Real Water's facilities in Henderson and in Mesa, Arizona. And it's separate and apart, Your Honor, from all of the water that the plaintiffs and other parties have pulled from these distribution centers, because we gave them the option to do that, and they availed themselves of that option. They took as much of this water as they wanted. What remains are these pallets from floor to ceiling of excess water. Excess water that by order of the United States District Court for the District of Nevada and by order of the Special Master has to be discarded. And it's excess water, Your Honor, that from a best practices perspective for our clients needs to be discarded so that it's not inadvertently intermingled into the distribution channel. Yeah. Just to reiterate, it is excess, not evidence. It will be tossed down the drain. The only thing to determine here, Your Honor, is whether we should try to learn something from that water before we discard it. And I think, fortunately for all the litigants, and fortunately perhaps for the court, Rule 26 answers that question in the affirmative. Rule 26 enables us to do work product testing on this excess, not evidentiary water. It lets us try out our case theories. It lets us try experts from different disciplines. It lets us try out different test methods. It lets us hunt for different potential target analytes. And it lets us try to determine which lots, which production dates, which size water, which SKUs we should test. Rule 26 does all of those things, Your Honor, in advance. But we're here because the Special Master, for reasons that are entirely unclear to me, rewrote Rule 26. And he essentially wrote the work product protections that are in 26B3 and the non-testifying consultant protections in 26B4 completely out of existence. And he said, you may not do that testing on this water even if you are about to throw it away. So we're in a bind. We have a July 31 trial date in the Gallagher case. We have a mystery that the public health entities have been unable to resolve for months and months and months. And yet we have a prohibition against testing exactly of the sort that Rule 26 encourages us to do to develop our cases. And I'll speak in terms of defenses, Your Honor, but the same, of course, is equally true of the plaintiff. Plaintiffs deserve the same opportunity to do work product testing here that the defendants do. This isn't secretive, Your Honor. It's not destructive of anything that's not already going to be destroyed. There is no cost at all. There's no potential for prejudice because this cannot be introduced into evidence. All it can do is illuminate the parties' trial preparations. So we believe, Your Honor, that we ought to be entitled to do the work product testing under B3 and the non-testifying consulting testing allowed under 26B4. We're not, in other words, asking for a single thing that the rule doesn't already provide. And if we do that testing, Your Honor, and another party, whether that's plaintiffs or a co-defendant, believes that it has a substantial need for the results of that testing, then it has a mechanism under B3 to demonstrate substantial need and obtain that, or to demonstrate the exceptional circumstances under 26B4 and to obtain that. So again, the rule as it's crafted provides an answer here. But in the interim, Your Honor, I ought to be able to select consultants of my choice to deliberate whether I should retain chemists or metallurgists or virologists or microbiologists. I ought to be able to talk to them about what tests they think would be most illuminating here. I ought to be able to talk to them about what analytes to target that might possibly cause the liver injury that plaintiffs claim. I ought to be able to talk to them about what water we ought to test to demonstrate the merits of the plaintiff's case. And I ought, Your Honor, to be able to do all of that without the plaintiff's attorneys lurking over my shoulder, just as they should have the privacy and the independence to do that our adversarial system guarantees without me lurking over their shoulder. So again, Your Honor, I'll stop there. I'll rely on the papers otherwise. I'll simply say that Rule 26 gives us this right two different ways. Gives us this right whether that testing yields facts or opinions. And it gives us that right in B3 and B4. I'd ask that the court enforce the rules of discovery here and correct the special master's error in rewriting Rule 26.
Thank you. Let's take joinders in the order of your appearances, and I'll ask the oral joinders to be 2 minutes or less.
Your Honor, Joel Odou for Affinity. We filed a written joinder to this motion, but I don't anticipate I'll be longer than 2 minutes, so I'll comply either way. We've joined in the arguments of UNFW, and the only things that I would add to the arguments that Mr. Neale made, which I think hit all of the points, is the distinguishing fact here, and what distinguishes this issue from all the cases cited, is this isn't the water that the plaintiffs allegedly consumed. This is water that is going to be destroyed. If we look at any of the cases cited, whether it's cases talking about iPhones or cases talking about other injuries, it's always the mechanism that's purported to have caused the injury where the court has had to do a balancing act and weigh the work product protections versus discovery. That's not what we have here. We have mountains and mountains of excess water. And so that's the first distinguishing fact. The second issue that I would raise is the special master obviously is very qualified and has done his best. But in this case, we think the special master erred. The special master's ruling basically was that 16.1 swallows the work product privilege. And for the reasons I've cited, the fact that this is distinguishing water, this isn't water that was the mechanism of injury, we don't have custody of the water the plaintiffs consumed, and the fact that this water has to be destroyed doesn't make it a 16.1 disclosure that, hey, here's what this water contains. We know what the water contains. John Marlowe, the inventor of real water, testified last week as to what is supposed to be in the water. And so this argument that causation testing is now discoverable really flies in the face of the work product protections, and that's really why we're here. We're arguing that we should, and plaintiffs don't even dispute causation is at issue here. The plaintiffs know that medical causation is at issue, they know that actual causation is at issue, and they want to know what we do to test to show causation. And we think the work product protections protect us when we want to test for causation, and that's really all we're asking.
Thank you. Other joinders?
Morning, Your Honor. Colt, Dodrill, bar number 9000, counsel for Nevada Beverage in the coordinated matters. We filed a written joinder. I don't have anything to add other than you saw the pictures. We've got 91,000 bottles of water, and our concern is the special master's order creates a disincentive to get that water tested, and any water that's going to be discarded is essentially trash, and we should be allowed to learn from that.
Thank you. Other
Good
joinders?
morning, Your Laureen Frister for defendant KeHe Distributors of Nevada. I agree with the arguments made by defense counsel. I have nothing else to add except that in the past, we have never had to disclose testing by a non-retained consultant, and there is no justification for changing the rules now for this case. Thank you, Your Honor.
Thank you. Anyone else before I hear from the plaintiff? All right, plaintiffs.
Thank you, Your Honor. First, as to the comment by Mr. Neale about no FDA testing on any of the concentrate water or any other substance revealing any evidence of an adulterated substance, I would respectfully disagree with that. for the record, although it's not relevant here. I would agree that the FDA testing on the final water did not conclusively reveal the toxin that was believed by the FDA, CDC, Southern Nevada Health District to make people sick. In explaining that, the FDA also explained several reasons why that despite believing that the real water is what caused the injuries that they looked at, that they weren't able to identify the substance in the final product for testing. One of those explanations was, well, it's possible that the water that we tested was not representative of the toxic samples. And they gave another several reasons why there could be variations in every single water sample. All the mountains of water samples that they're showing you and telling you exist, they're all unique samples. And they all have the potential of being the one and only sample that just happens to reveal probative information about the ingredient and the toxin at issue. And so, boiled down, at the heart of this dispute is the simple issues. As Special Master Hale said in his order, one of the factual questions in this case is, what is in the water? What is the contents of this water? The question before Special Master Hale and now before this court is, if a party obtains purely factual data regarding the contents of a unique sample of water, should they be allowed to conceal that data from the other parties? And to be clear, this is purely objective data. It's empirical laboratory test results. It is not subjective analysis or opinion or a theory about what's in the water. It is objective test results. The substance is either in the water or it's not. The ingredients are there or they're not. And during the hearings, multiple hearings on this issue with Special Master Hale, who very thoughtfully considered the briefing, considered the issues, took arguments over 2 special master hearings, he asked defense counsel point blank, if your test results, if you're allowed to just say you're destroying all this water, not really destroy it and run all these secret tests on it, if those test results just happen to be the one that shows, reveals the probative information about something in the water, is it your position that you're entitled to conceal that evidence and not disclose it, those facts? And you know, that it was a tough question to ask. They tried to avoid answering it, but ultimately Special Master Hale pinned them down and they said, yes, that's our position. We can test this, and if we find something, we can choose whether we reveal it or conceal it. And that's what this came down to. And Special Master Hale correctly rejected that notion. That's not what Rule 26 allows. That's not what the purpose of discovery is. Special Master Hale said, look, we're talking about the contents of water. What the laboratory results, empirical testing results show is in the water that's tested. If you test the water and you have empirical data about the ingredients, you have to disclose those ingredients. That's it. He did not say you're prohibited from doing any testing. He did not say that you're required to disclose your conclusions, mental impressions, or analysis of the objective data. He did not say you have to identify any of your experts, consultants, non-testifying experts. He did not say you have to disclose your communications with these experts. He simply says that if you test the water and you have empirical test results regarding the ingredients, you have to disclose those objective facts, the straightforward contents of the water. And he said those facts are not work product. And he didn't make that up. He didn't rewrite the rule. He cited Nevada case law. He cited the federal district court opinions where they found that exact thing. In his order, on page 2, he cites the OVA Innovations case and quotes it, or describes it as a discovery dispute arose regarding the regarding forensic images on the computer. And that court looked at it and said, the forensic images, the data, the objective images themselves are not work product. That is disclosed. The analysis, the conclusions, the mental impressions, the discussions, that is different and distinguishable from the factual data. That is work product. So that doesn't have to be disclosed. That's what Special Master Hale did here. He said the empirical test results regarding the ingredients are facts that need to be disclosed, and how each side analyzes that, how they formulate their theories, their impressions, how they use it as part of the strategy in their case. That is what's work product, and that is what is not protected. That is what is protected from disclosure. They repeatedly said that, well, there was a mention that, oh, if we can demonstrate a substantial need, then we can get the test results. But that conflates two issues. The first issue is whether this empirical data in this circumstance, under these facts, is work product. Special Master Hale said it's not work product. But even if it is work product, which it isn't, and Special Master Hale correctly found that, it's still subject to disclosure under Rule 26, because this is information that they're telling you. We want to say we're destroying this, then we want to test it without telling you, and then we want to conceal the results. And when you test this water, you destroy it. It's destructive testing. You have to destroy the water. And if they don't reveal the test results, how do we know what to ask for? How do we make that substantial need showing? The substantial need showing, it doesn't relate to test results that we don't even know exist because they're doing it in secret and not disclosing anything about it. It relates to this exact scenario, that if you're going to test it, you have to disclose it, even if it is work product, because we have no way to know that it exists. We have the relevant facts about what's in the water, and we have no way to recreate destructive testing that they perform on some unidentified sample. So under either separate issue, whether the objective data is work product, it's not, it's discoverable, or even if you were to buy the argument that it potentially is, it's still subject to disclosure. Just the empirical facts, not the conclusions or anything else, because there's no way for us to know about it. It's relevant information, what's in the contents of the water, and we have no access to it because it's destructive testing. Just commenting on some of the other final comments from Mr. Odou. You mentioned that, we know what's in the water because John Marlowe, the inventor, said what he did, what he put in the water. That's a red herring. We don't know what's in the water because they're trying to put the causation burden on us and say, well, it's their burden to prove causation, but we want to figure out what's in the water, and then if we find something that's probative to either causation or defenses to causation, we want to conceal that information. So we want our cake to eat it too, and eat it too. It's an unreasonable position, exactly as Special Master Hale recognized it so. He developed the fair compromise to say the objective facts are what's discoverable, the subjective analyses of those facts are what is privileged. Exactly like the Innova case that he cited, which is the objective images are discoverable, how you analyze them is work product. And we ask that you, we respectfully ask that you affirm Special Master Hale's order.
Thank you. Mr. Parker, do you have anything to add?
Your Honor, let me answer that question with a question, Your Honor. You're very well read. I've spent a lot of time before Your Honor. Does the court have any questions or concerns?
No. And I
Good.
believe this is a light week, so I was able to read everything twice.
Perfect.
All right, then, Mr. Neale, your reply, please.
Thank you, Your Honor. Briefly, the reason that Nevada Rule of Civil Procedure 26B4 and B3 shield the results of work product testing is because those results inevitably contain the mental impressions and trial strategy of counsel. If I do testing and I'm forced to reveal the results of that testing, my adversary learns whether I think the problem is a chemical one or a biological one, whether I'm looking for potassium or vanadium, whether I think that EPA method 200.7 or FDA BAM 25 is the right method, whether I think the water from the 5-gallon facility or the retail facility is the target product. All of those reflect my mental impressions. That's what the Schumacher said. It's the essence of work product that's protected by the rule. It is the subjective analysis. More fundamentally, though, Your Honor, Nevada Rule of Civil Procedure 26, and with the court's permission, I'll share my screen again. B3 protects facts and mental impressions. It protects documents and things that are prepared in anticipation of litigation, period. B4D, even more specifically, protects facts or opinions held by an expert who's retained but not testifying. The only distinction under the rules in Nevada between facts and mental impressions is the height of the hurdle over which the plaintiffs have to clear, or the opposing party has to clear in order to obtain that work product. It won't be a secret. There's a mechanism to get that under B3, and there's a mechanism to get it under B4. The rule already provides that which Mr. Pepperman says he needs. We ought to stick to the rules. Mr. Pepperman referred to a really hard question. I'll close with this. What would you do if you tested this and found a positive result? Well, that would be a wonderful thing to have happen for everybody. With that information, Your Honor, we could sort the meritorious claims from the non-meritorious claims. We could resolve those claims that have merit and litigate those claims that we believe lack merit. And maybe most importantly, Your Honor, we could prevent something like this from happening again. We ought to be doing everything we possibly can to encourage testing, to pursue the science that's out there somewhere that's going to give us the answer to this question, so that we can learn the truth and prevent this from happening again. That's exactly what Rule 26 allows us to do. And the court should simply allow the testing to occur under Rule 26. One final point, if I may. The testing protocol, which we agreed to with Mr. Pepperman, that's Exhibit G to the objection, provides Mr. Pepperman all of the relief he needs. It requires us, if we do work product testing, to identify the product on which we do it and to retain an identical sample of that same product, so that if Mr. Pepperman would like, he can do the same test. We've gone above and beyond the requirements of Rule 26 here. We've satisfied every possible need the opposing parties may have. We have a problem in these warehouses, Your Honor. Rule 26 helps us solve it, not just there, but in the courtroom. We'd ask that the court enforce Rule 26.
Thank you. Matter submitted. This is an objection to an order of the special master which prohibited work product testing of excess water. And I'm going to overrule the objection for the reason that I thought the special master gave special care and attention to the issue of work product and rejected the work product argument on good grounds. What he really did was preclude the defendants from concealing test results. Even with the mechanism that maybe you could get test results, I just find that his decision was well-reasoned and that there's no reason for me to disturb that. So Mr. Pepperman, Mr. Parker will prepare an order. It may be consistent with your briefs and may be more broad than what I have announced today as the ruling. And anyone who wishes to approve the form of that order, let them know so that you can be included in the review process.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
All right, thank you all, and Happy New Year, everyone.
Same to you, Your Honor.
You as well.
Thank you, Your Honor.
We have one last matter at 11 a.m. today, which is